Phony at this time.
Thank you. Thank you, and I'm glad that we're having the opportunity to talk about this. I'm too close. Talk about this publicly. Obviously, we've taken some, as a board, taken some criticism for some of our past decisions related to this matter. And as a member of this board, obviously, that includes me as well. I do think that some of that criticism was fair, but again, it is part of this public discussion. I think it's important for us to clarify some key points related to this. Number one, I think the decision on July 21st that we made to place Sabina Matos on the ballot or to not hear any of the objections was the appropriate decision, because based on the evidence that we had in front of us, that it was absolutely the appropriate decision that we had at that time. And as a quasi-judicial board, it's really important that we follow the evidence we have in front of us. We can't just make decisions based on hearsay or some other matters that are just not factual in front of us. And so even if we had, just been important to note though, even if we had accepted those objections, Sabina Matos still would have had enough signatures to make it onto the ballot. And I think that's an important point. One other thing that I think is very important to mention is that the process itself, while not perfect, has worked. We wouldn't even be having this discussion if the local boards of canvassers had not done their job and discovered those signatures that were incorrect, either potentially fraudulent or did not qualify. So I think as part of that process, it's also important to stress that all of those signatures were checked. So the local board of canvassers have checked every signature. However, that being said, there's clearly room for improvement in the process. As someone who has taken part of that process as a local board, at a local board of canvassers level, I can tell you that there are things to do, and I'm sure we all individually have ideas on how we can improve that process. But as I considered this issue and talked to people, I thought about it, and I thought that perhaps some of our actions may have caused people to lose faith in the process. And I don't think anyone of us I don't speak for anybody but myself, but I don't think anyone wants that to happen. So I think in addition to the discussions ongoing that we need to have about how we improve the signature process amongst ourselves and amongst other parties that are involved, I do think it's important for us to take a closer look at the signatures related to this case. So as a result, I'd like to make a motion to direct the Board of Elections staff to review all of the signatures for the papers submitted by Sabina Matos, all the nomination papers, and whether that is to use seasonal staff or potentially augment from local board of canvassers in the 2nd district. So basically people that have not looked at those signatures to actually look at each of those signatures, not just the ones in question, but the entirety of all that paperwork, and to validate those. So I'll make that in form of a motion. I'm sorry if it was a little
We have
sloppy.
a motion. Do we have a second to Mr. Jackboni's motion?
Second.
Seconded by Ms. Bettencourt. Any discussion of the board?
I actually have some discussion. Madam
Okay.
Chair.
If I might go first.
Absolutely.
I've been criticized for not speaking for the board, and I am but one member. We all have differing opinions. Today, I speak for myself. The board's vote on July 1st to certify the ballot ended the signature review process and any further review. In the past, we have pressed for more time to complete the certification process, but only the General Assembly can act to make that happen. The board correctly referred this matter to the Attorney General to investigate fraud. The board is not equipped to conduct a fraud investigation, thus the referral to the appropriate agency, the one that can bring fraud cases to court. I am confident in the work of the local board of canvassers, as Mr. Jackboni has said. They've had this responsibility for decades, and I speak as someone who did this very work myself as a town clerk for 20 years. The process has improved considerably since then. The tools we have to compare signatures is much more accurate, and the training is on point. What has been constant is that the local boards and canvassing clerks take this phase of the election process very seriously. Their work has uncovered forged signatures, and in my mind, their work is conclusive. Can we make this process even better? Certainly. And we can work on that prior to the next election. The board's involvement is to hear objections to the work that the local boards have done, and those objections must be filed before the deadline per state law. Again, that deadline is passed. By statute, and am I correct here, Mr. Mercatio? Signatures on nomination papers are presumed valid unless challenged.
That's correct, Madam Chair. This entire process is governed by Chapter 14 of Title 17. The process is, for those here, would be similar to a funnel. At the top of the funnel, the local boards act as the review of all of the signatures. In that process, they hear any challenges to those signature verification. At the end of the funnel, in a very short period of time, 2 days and only 2 days, that's what our statute says, this board must hear any challenges that are submitted. That process ended by law on the 21st of July. Now, as I've said to the board in executive session, and here I can say that the board itself has plenary powers. Board has plenary powers. It can go beyond the statutory deadline when there is some evidence of impropriety with respect to fraud. If a machine's not working, then you can go outside of those particular statutory boundaries. Here, when there was a suggestion of impropriety, it was referred out to the Attorney General, and it was also provided to the state police.
Thank you, sir. So in my mind, the signature verification process ended on July 21st. The ballots have been printed and mailed to overseas voters, and early voting begins next week. I can't support any measures, while well-intentioned, to revisit the signature verification process, and the investigation into the process of collecting those signatures is in the appropriate hands. So I will not be voting for this motion. Does anyone else have anything they would like to say at this time? Mr. DeSimone, I know you said.
Yeah,
you
well,
did.
actually, I have a question for our legal counsel. So, Ray, with regard to the suggestion that we look back over the signatures, absent some finding of fraud, we really don't have a means to do anything about those signatures. Am I correct?
You would either have to have a initial determination that there has been fraudulent conduct or some other type of impropriety. So if you, just like we had 40 plus years ago, if you had a machine that doesn't work, the board can call a special election if it had to. That's an extraordinary remedy that in the 40 years since then, I don't think the board has ever exercised that, gone to that extent. But yes, if there's something, even apart from fraud, where there is a impropriety or the system did not work, you could take further action. The thing that I asked the board to consider, and I think Mr. Giacomone is considering, is, is there evidence of fraud with respect to the nomination process? If this board determines that there is some indication of that, it could either refer the matter out, as it has. It could take actions internally. And that is entirely up to the board. The question for the board would then be, are the measures that are being considered going to achieve those goals? That's only for the board to decide. That's for the 7 of you to look at and make that decision. Will the review of the signatures advance the concern that the board had either with improper process, fraudulent conduct, or something else that falls outside the ordinary course of the statutory process?
So, Madam Chair, based upon
Does that help? I mean, did I answer your
that's
question?
extremely helpful.
All
So
right.
based upon those comments and based upon the situation we're faced with, I think the board has to look at 2 things. One, are we satisfied with the process as it exists now with regard to the investigation, not with regard to the checking of signatures? I'm not suggesting that a board of canvassers can't compare my signature with my voting card. That becomes somewhat subjective. So I'm a little concerned about stopping at that point. I think that's a good starting point. I think in addition to that, and I would support Commissioner Giacofoni's motion, if in addition to that, this board would consider starting its own investigation. And by starting its own investigation, I would begin with questioning each one of the parties who procured the signatures on the nomination papers. I would ask that a hearing be convened, that they be brought before this board, sworn, and testify as to the signatures on there. Because when I read in the newspaper and I see online that voter after voter is coming forward, albeit to news media or any other party, and they're saying, I didn't sign those papers and my name is on them. We've heard from Jamestown, we've heard from Newport, we've heard allegations out of Barrington, we've heard of a gentleman out of North Providence, all of whom claim their signatures were not on those nomination papers. I think at some point, the parties who procured the signatures on behalf of the campaign have to be brought to task on that. And I understand that at times this board has suggested that, well, they attest to that fact when they sign the back of the nomination papers. And I know council has told us that on the back of the nomination papers, they swear that before a notary, that these signatures were garnered by them. And I would suggest to the board that it's a vast difference in somebody signing the back of a document under penalties of perjury or coming before this board in public and testifying as to how they got those signatures, particularly with regard to parties who either don't live in the district or have deceased since the last time that the signature process was reevaluated. So I would support the motion, but only if this board is going to conduct some type of investigation along with simply looking at the signatures.
Mr. DeSimone, I understand what you're saying, but I'm just wondering what would the process of us referring this to the Attorney General for that purpose?
Well, at this point, then I think maybe we should inquire as to where that investigation is. We submitted this on July 21st.
Correct.
And my understanding from, again, watching the nightly news and reading the newspaper is that the Attorney General, and he may be correct on a legal basis, said it's not his purview. They've opened up a criminal investigation. As far as I know, the criminal investigation extends to an individual who collected signatures in Newport and Jamestown. I don't know of any of the details of the investigation. I think that, and I'll ask our director where we are in the investigation, but my understanding is that they picked up nomination papers, and that was approximately 2 weeks ago. I think the concern that this board has to have is that a criminal investigation can take months, and properly can take months. I mean, the standard is reasonable doubt, and it's we're talking about a criminal standard here. So we're in a situation where there's an election. I think that the people have to be assured of the integrity of that election, and they have to be assured that everyone who's involved in the election has done so legally. So I think our burden goes beyond what the Attorney General's burden is. And I don't think that, at least I, for one, at this point, from what information I've garnered, I'm not happy with the process of the investigation at this point in assisting us. I don't make any comments on the criminal investigation. That is what it is. But I don't think that investigation is intended to assist us in keeping with the integrity of the election. So that's the concern I have. I would request that in form of an addition to the motion, if I may. I would ask the mover in the second to support that. I would ask the rest of the board to support that. I think it's as simple as issuing, I believe, 11 subpoenas and holding a hearing here in these chambers. I would also defer to our executive director if he has any additional information on where the investigatory process is.
I would like to hear from him as well. Mr. Reposa?
Good afternoon, members of the board. The nomination papers were turned over to the state police on July 25th. Last week, on August 1st, I touched base with the state police and the Attorney General's office. The investigator that was being assigned to this case was coming back from vacation on August 1st and would be provided the scope of the job at that time. Yesterday, I called the state police to the individual that I provided the papers to. He was not available as of right now. He has not called me back.
Okay.
And my understanding to the director is that the original documents are in state police custody now.
That is correct.
So before we could even review them, we would have to get them from state police custody, or do we have some copy we could use?
I do have copies.
Any other comments, sir? Mr.
Yes.
Scholes?
Yeah, Madam Chairman. I don't know what this review is going to. Sorry? Oh, yeah. I don't know what this review is going to accomplish. We've already certified that the candidate is qualified to be on the ballot. She submitted 1,200 signatures plus, and she qualified with over 700 and plus signatures. And all we know right now, we got about 12, maybe 18 people who said the signatures were forged. That's a very small amount. It's not tantamount to widespread fraud. The General Assembly, when they drafted legislation, and I'll just read a statute that talks about fraud and signatures, they anticipated that there will be fraudulent signatures. Said in the very last sentence of Rhode Island General Law 17-14-11, dealing with checking and certification of nomination papers and challenges. It says if any challenged signature is found to be invalid for any reason in law or forged, then the signature shall not be counted. So we relied upon the Board of Canvassers to do their work. They found signatures that did not match those that are on the voter registration rolls or in their cards, and they crossed those out. Whether they're forged or they couldn't make it out, the signature was not counted. All they did was match a signature with a signature. It's a subjective thing. Going back and asking them to or bring in these additional eyes to take a look at it, they're just going to match and match. There's no way for them to know whether that signature is forged. Someone can forge your name. A forger, that's a forgery. Someone who signs your name that doesn't match at all, that signature is crossed out. Okay? This has happened many, many times in the years that I've been on the board and the years that I've been involved in politics. People have signed for other people. Okay? People have gone to a house and said, I'm running for office. Here's my nomination papers. Can you sign? Oh, okay. I'll sign for my husband. They sign the name. Well, can say that's a forgery, but Board of Canvassers will cross that out. This process worked. These names are crossed out, and the person qualified for those for the spot on the candidate on the ballot. Now, this was all brought to us about the forgery, and we submitted the whole thing to the Attorney General for their review. If someone committed a crime and actually forged names, they're going to be held to account in a court of law, and they'll respond to the bar of justice. For us to go and now investigate this whole thing, we're going to be duplicating what the Attorney General has done. And I don't want to get involved in their criminal process. Okay? They have to speak to witnesses. They have to take statements. In fact, the Attorney General said to the local police departments, please do not get involved because we only want one investigator in here. Okay? Don't you investigate, then we have to go back and talk to the same witness. So there's only one team. That's the Attorney General and the state police. I say, let them do their job. Okay? If they find that a group of people were involved in forgery, they'll bring them to justice. Right now, we have an election to run. We have voting machines going out, early voting starting next week. We have a small staff. We can't take our resources and apply it to this investigation and not work on this election. We want this election to be fair and run without a problem. And getting involved in this, we're going to create additional problems for our staff. So, for that, I can't support it, this. I can look at later on, after the smoke clears, after the election, to go back and revisit this thing and go and see what was good and what was bad. Okay, and if necessary, make the appropriate changes. But at this time, I don't think this is an appropriate use of our resources. And for that, I'm not going to support this motion.
Thank you, Mr. Scholes. Anyone else have anything they would like to say at this time?
Madam Chair.
Yes, Mr. Connors.
Madam Chair, if I may, I would also like to commend the local boards of canvassers. I think by and large, the process did work. If the candidate submitted nearly 1,200 signatures, almost 500 of them were disqualified. However, in light of certain media reports of signatures that made it through, and under those plenary powers that our attorney spoke about earlier, I'll be supporting this review in order to ensure that the public has confidence in this election. Thank you.
Okay, thank you. Did you wish to say, Mrs. Johnson, did you wish to say something?
No, I'm not going to, yes, thank you, Madam Chair. Not to belabor any point, but I think I've definitely thought about this a fair amount. Being really honest, I think we should have reviewed the signatures 2 weeks ago. I think we should have taken the time that it took to do that. I think, given the report of our executive director, this was unprecedented in the numbers. 18 to 20 fraudulent, egregiously fraudulent signatures is too many. And given the fact that we haven't seen this, I think we were faced with something we never had before. The way that we acted, myself included, and I can only speak for myself, I would have done it differently had I had to do it again. I think why I will support this motion is I feel like in terms of the voters deserve there not to be a cloud over this process. Also support the boards of canvassers, the cities and towns. They work very hard. It is on us as a board to take a closer look at those structures and that process and make it more conducive and consistent so that the local boards and canvassers don't come under question. I do not question them, but everything can be flawed. And this is something I think that we need to take a closer look at. I think the trust of the voters is most important. I also think for the campaigns and the candidates, including Lieutenant Governor Sabina Matos, as we move forward, to Commissioner Scholl's point, we do have an election to run, but there should be a little more clarity, I think, in this particular case. And, I think we need to do better in the long term and working collectively with the boards of canvassers, with the Secretary of State's office, and with the staff of this body. I don't think anyone's questioning anyone's commitment to the work and the commitment to fairness, but I do think this is something that deserves a closer look, whether or not it changes the outcome. I think it's worth the few hours that it will take to have some clarity, and for that reason, I will be supporting the motion.
Mr. Jackborn, you've heard Mr. DeSimone's comments. I don't know if you wish to amend the motion.
I think that Mr. Commissioner DeSimone's suggestion is certainly worth further discussion, but I think I want to keep the motion as it is. Now, if we subsequently want to discuss the secondary of, it sounds like potentially subpoenaing the 11 people who took, I think it's 11 that did gather those signatures, I certainly think that's a worthwhile discussion, but I'd like to keep the motion as is. I just want to make one quick clarification in case it wasn't clear from my initial comments. I think all of us support the local boards of canvassers. They all work very hard. I've seen it firsthand for many years in Cranston. and I was very careful not to use the word fraud or certification. I don't know what is going to come out of this. If I was to guess based on my experience, I think we're going to find probably a handful of signatures that shouldn't have counted and a handful of signatures that probably should have counted. I think at the end of the day, the number of signatures is not going to change that fundamentally. But I think based on our role as a board of elections, the oversight of all the entire electoral process, and the fact that we can learn something to improve, not 6 months from now when we're staring down another election, but right now we could learn things that we can share together with the boards of canvassers to help them to learn, so we are more standardized across the state. That would be my goal in terms of the process, and make sure we're all taking the same types of training. So I think there's a lot of a learning experience. Now, if at the end of this we find that there's fraud, well, I think we'll deal with that when it comes to that. But based on that, I would just say I've run for office on several occasions. I've collected signatures. If someone came to me and said, I'm going to have a sign for my wife, I would have not let them. That is part of the process. So we need to, again, that might be some information that we need to take into account from the training purposes. So thank you.
So just to clarify, Mr. Giacone, your motion was to review the signatures on,
Yes, to review all of the signatures as submitted for Sabina Matos for the CD1 race.
and we have a second by Ms. Bettenker. Do we have any further discussion on the motion?
No, Madam Chair, I'll be prepared to vote on the motion, but before we adjourn, I want to make a second motion. So
But
Okay.
before, so
Understood.
I understand the motion, because I do think it's important that you have the basis, because this would be unique to review the signatures again. Are you seeking to review them under the verification process of Chapter 14 or the plenary powers of a review of potential impropriety under Chapter 7?
The latter.
Okay.
So that's clarified, right?
Yes.
Any further discussion? Hearing none, we shall vote. All in favor of the motion signify by saying aye and raise your hand, please.
Aye.
Those opposed? So the motion is passed 5-2.
Madam Chair, if I may,
Mr. DeSimone.
I would request that the board consider my second motion of establishing, or at least beginning the process of our own investigation, because I think the Attorney General's investigation is going to be, it just appears that it is going to be well post the election, and it is also going to be confined to two individuals that have been prominently portrayed in the media. And I think that all the individuals and all the papers need to be reviewed. If we're using our plenary powers, let's use them. And so I would move that we ask our counsel to issue subpoenas and have a hearing for each of the parties collecting nomination papers for Sabina Matos. And that we do that as soon as possible, and we issue those subpoenas for sometime next week.
We have a motion by Mr. DeSimone. Do we have a second to his motion?
Can I ask a clarifying question?
Of course.
As a non-attorney, I'd love this clarification. So we would subpoena them, sorry, that is making really weird noises. And so would our goal be to add on to the investigation, or what would be the results? This is legitimately just asking for my clarification. So we subpoena them, some may or may not show up. I guess my question is, what would be the results or the actions that we can and cannot take after that? I guess that's my clarification.
Well, I mean, I would defer to legal counsel. I would suggest if this board subpoenas someone and they don't appear, they would be subject to a contempt proceeding.
The board has contempt powers. We have exercised those in the past, primarily with campaign finance matters, but we do have contempt powers by statute that are equivalent to a sitting judge. So you could proceed that way. If someone were to present evidence of not gathering the signatures, that would be referred out typically to the Attorney General. I mean, in some ways, we would be going in a circle, because typically under Title 17, the board reviews anything on elections on a civil basis. When it comes to a criminal basis, we are, for lack of a better term, joined at the hip with the Attorney General. They would be conducting investigations, prosecutions, et cetera. And that happens, for example, even under Chapter 25 in a campaign finance circumstance. Under 1725-16, the board works with the Attorney General for the process of bringing someone before court when there's been a violation of campaign finance. So I don't know what else you would do other than that, but it would, of course, call into question the signatures that have been gathered on that particular paper.
So Ray, if, for example, a party or parties came before us and invoked their Fifth Amendment privilege,
Right.
what would our recourse be at
Well,
that point with regard to
so-
an inference against those papers?
Right. So my memory is going back now to June of 2002 when this happened last, when I was just representing you for a matter of weeks, if not months. My recollection is that it happened exactly that way with a candidate. The candidate pleaded the fifth, and we then rejected those papers because the candidate signed all of the gathering signatures. That went up to the Supreme Court. The Supreme Court said on an emergency basis, with a one justice, duty justice hearing it, that it would be better to narrowly tailor the consequence of the bad act by striking those signatures on the papers that were not viewed in the presence of that person, number one. Number two, we then referred it out to the AG, and my recollection is that person then was indicted and pleaded and was convicted.
But prior to the Attorney General taking action, the papers were stricken by this board.
We struck the papers after going up to the Supreme Court. We struck the offensive signatures that were not gathered in the presence of that person.
So my query would be, if we asked on each and every signature and they took the fifth on each and every signature, for example, let's say 25 signatures on a page, the board could then infer that all 25 signatures were bad. Is that correct?
When you say they're bad, you've already certified under 1714 the results. The 700 plus are a number. Whether you review these with another set of 20 eyes or 5, whatever you do, by law, those numbers remain until there's some other determination by this board. So you would have to create a factual record to justify removing any. And I frankly have never seen the board go back to try to change the results of the nomination papers, the number of signatures that have already been certified to the Secretary of State. I would have to do research on that, Mr. DeSimone, because I'm not even sure we would still have the statutory power to change those numbers, but I would have to look.
So then reviewing the signatures themselves without any testimony, without any facts coming into evidence, simply reviewing them and look at them, what is the board's power? in
Well,
that
the
regard?
board has the power to review them, to assess whether it wants to do things differently in the future, whether it thinks the numbers, that maybe the process was defective. For example, I remember recently we reviewed signatures again within the 22-day period, and we were disappointed that some local boards did not codify the reasons for rejection, so the person who's watching the process wouldn't even know why the signature was rejected. So we cured that. We took corrective action, and to my knowledge, we now have a uniform set of codes, which is great. Beyond that, Mr. DeSimone, I wouldn't want to suggest to the board that if they review the signatures, that in and of itself it could not be the end of a process, because you're talking about an investigation. Reviewing signatures would be, I guess, the first step. But those signatures have already been certified.
So we in effect, as it presently sits with the motion that was presently made, we're going to be reviewing signatures that we've already said were good.
We have said they're good because the
The local-
local boards have
correct.
said they're good, and there was no challenge to those specific signatures. There have been things that have been reported where people have said that wasn't me, but that would have to be something that you'd have to create a factual record on. You'd have to have them before you. You couldn't just call people and expect that would be hearsay.
Mhm.
There's too much writing on this, and I think you'd have to do it correctly. In my judgment, given my years of advising you, if you look back at the decades now of how our board has acted, we proceed with deficiencies on the elections. When it comes to fraud, we refer it out to the AG and ask him or her to get to the bottom of any kind of criminal misconduct. We've always done it that way.
But we refer it out once we've discovered some indication of fraud, correct?
Which is what we've already done, yes. We have met now for almost 4 hours in executive session. We've discussed the intricacies of what we're aware of without trying to influence an election. We've had those discussions in executive session. At the end of that process, we provided 111 pages of nomination papers. Every single paper has been referred over to the Attorney General and the state police.
And they assigned it on August 1st, as far as we know.
I wasn't part of that conversation. I have no reason to doubt that. I'm just not sure if that meant they assigned it to the Attorney General or if the state police started this before. I can't say.
Well,
I think, and I can tell you that back in 2002, my recollection is that the indictment was, many months after, as you'd expect in a criminal.
Mhm.
But that doesn't mean the process didn't work. I think it proves that it did because somebody was convicted of that. We have yet to hear anyone say that anything that has occurred to date would in any way be capable of statistically mathematical probability affecting the outcome of who's on that ballot. That will be different.
Just so it's clear, as a commissioner on this board, my concern is that there was alleged fraud, and it seems pretty obvious in a couple of the cases for two of the people who are collecting signatures. And that seems pretty obvious based on the facts as they've come out. And I, for one, don't have a lot of confidence in simply saying, well, okay, all the 9 other gatherers did a great job. So that's the reason for my motion. Frankly, I don't expect it to pass based on the comments. I don't expect it to get seconded based on the comments, but that's just my position on it.
But one other thing I'd like to say in this, I haven't listened to every single thing the Attorney General has said. He certainly does not have to report to us. He's conducting a criminal investigation, but I haven't heard him say that he's limiting the scope of his investigation to 2 gatherers. For all we know, I mean, he certainly has all 11 gatherers that they've all been referred to him to use his prosecutorial discretion. He's got to look at this carefully in a way that, speaking candidly, I would be concerned about having people discuss this openly at this juncture as opposed to our 2-day period, because this could be going on right through October, and there are people on the ballot who could be affected by that kind of a public review. No, I'm not a board member. I just want to give you my own experience as a lawyer.
Thank you, Ms. Marcaccio. Did you have some?
I'd just like to point out that the Attorney General has a tool that we don't, and that is the grand jury. Attorney General can bring in the witnesses and put them under oath and ask them the questions and get to the bottom of this. They have the tools, they have the investigators. They can go out and find out who committed the fraud, if there was fraud. I think I have confidence that the Attorney General can do that. But as to a point that was raised here with respect to the nomination papers, I think there's a point that says that if there's a forged signature, or a series of signatures on nomination papers, does the entire nomination paper, is that invalid? Is that to be scratched, not be counted? Now, the Supreme Court in 1997 or 77 issued a ruling that says tainted signatures, if crossed out, does not taint the entire nomination papers. You count all the good signatures on that nomination papers, even though they may be forged signatures. So we have to bear that in mind. No, we just don't toss out the nomination papers. You just look at the forged signatures. Really, and the only way we're going to know there is a forged signature. If someone comes forward and says, someone signed, I didn't sign that paper. That's the proof we need. Otherwise, it's just hearsay. It's just a match or mismatch on a digital signature. I don't know what we're going to accomplish with that. We're going to come up with probably the same number as the Board of Canvassers did, and we're going to be wasting a lot of resources to do that. And the only way we know is there are people out there who said that they did not sign the nomination papers. I tell them, go to the Attorney General or the state police and make known your concern, or contact us and we'll refer the name. But we need the names of those people. Otherwise, we're not going to get down to the bottom of this. And I think the Attorney General has the tools to do that. So
you,
that's
Mr.
my
Schultz.
piece. Thank you.
Thank you. So Mr. DeSimone's motion, we still do not have a second. Is there a second to Mr. DeSimone's motion to issue subpoenas for the parties who collected signatures from?
I just have one more question.
Okay, Mr. Connors?
Madam Chair, this question will be for the council. Is there anything to prevent us from using our subpoena powers if during our review from the initial motion, if something came to light, something egregious, is there anything preventing us from using our subpoena powers as part of that review process?
You mean without a further motion, without the board actually authorizing it?
Without a motion now.
No, ordinarily, you would reconvene for that limited purpose. You'd have someone come before you to say, here's what we're developing, and it suggests X. The board could then say at that point that we should advance this to a subpoena of those signature gatherers, much like we did back in 2002.
But we'd need a meeting to do that, correct, Ray?
We would.
That would be my recommendation, to have a meeting to authorize those signatures. I would have to check the statute. The statute quite possibly gives the quote secretary, which is under current parlance, your executive director, some authority if done with the consent of the chair. I'd have to check that. I could check that after this
Would
meeting.
it be
Thanks, Ray.
possible to do an emergency meeting of the board if that is the case?
If, given where we are in this process, to give you a quick answer, yes, I believe so. I would have to give that a little more thought, because you're talking about it impacting the very ballot that's being sent out right now
True.
across across the seas to to people overseas.
Mr. DeSimone, do you have anything further?
No?
Your motion still on the floor?
Mhm.
Do we have a second to Mr. DeSimone's motion at this time? I don't believe we do, Mr.
Okay.
DeSimone.
That's fine.
Any further discussion? So, Mr. Reposa, we have a motion that was passed, and I'm just wondering how we are going to effectuate the action that has been requested of this board, by this board.
What the staff will do is we will ask our seasonal staff, the people that worked in the mail ballot room, to come into the office. We will we're going to ask for the original nomination papers back. If not, we will use the copies that we have. And then we will train these users on how to operate the central voter registration system. I would ask at this time if you ask Rob Rock to come forward, because the Secretary of State's office is in charge of the maintenance of the central voter registration system, and he can give you what exactly has to happen and how long it will take to
Perfect.
get these users access to that system.
Perfect. Mr. Rock, would you mind coming forward, please? Could you please brief us as to what the process will be?
Thank you. Good afternoon, Chair, members of the board. Rob Rock, Deputy Secretary of State for us, Secretary of State Greg Amori. We will, actually, probably now, our elections team will create the accounts for the users that the Executive Director referenced. We will create the multi-factor authentication keys that you need in order to gain access to the voter registration system. And then we will provide the same documentation that we provide local boards of canvassers on how to validate signatures, not handwriting expert stuff, but I mean how the process works where you log into a voter's record, you pull up the signature, you match that signature to what's on the paper. We will provide all of that documentation before the end of the day. And Bob, your team will be ready to start work tomorrow from our end.
Thank you.
Any questions of Mr. Rock?
Thanks, Rob.
Thank you. Appreciate the input. I believe we have looked at the item on this agenda and we've acted on it. I think a motion to adjourn would be in
Move to
order.
adjourn.
Do we have a second?
Second.
Moved and seconded to adjourn this meeting. All in favor signify by saying aye.
Aye.
Those opposed, unanimous vote at 2:47 PM. Thank you, David.